We're going to resume now with Cliff Howard. He is an assistant district attorney at the Walton County District Attorney's Office here in Walton County. He's going to be speaking about the trial process and the role of the jury.
Good evening. I think I would begin this evening by saying that I couldn't agree. I'm in 100% agreement with what Judge Osborne had to say about jury duty and the fact that there's nothing more powerful than a juror and a group of jurors standing between the state who brings charges in criminal cases, and that's primarily that's all I do. Well, I do some civil cases, but primarily in a criminal case, you bring charges against the defendant. And in my opinion, all the prosecutors I've ever encountered, they do that with good faith, meaning they believe that they can prove that the defendant has committed the crime. But what's beautiful about our country is that a defendant who believes that they are innocent and they don't believe that the state can meet its burden of proving somebody guilty beyond a reasonable doubt of the crime that's charged, what stands between the state making a charge and putting somebody in prison, taking their liberty away, is a jury. And even though I've been a prosecutor for most of my career as a lawyer, I think that the duty of the juror to do that and to hold the state accountable for what they are required to do under the law is one of the most important things that anybody can do. And so tonight, with that perspective, I'm to talk to you about the trial process and the role of the jury. And you heard Sam Barth talk about the picking of a jury. You heard Judge Osborne talking about why that duty is important, and I kind of echoed some of that. And you heard Judge Ray talk about what happens if someone is convicted, and he has to deal with the case on appeal. So what I'm going to talk about is what happens after you've been picked as a juror. And that means, generally speaking, and I don't think Sam got to this, but generally speaking, there are 12 jurors in a criminal case. Sometimes there'll be 13 or 14 if the case is going to take a little while, and those are alternate jurors. In case a juror can't come in because they have a death in the family or someone's sick or an emergency, there'll be 12 to 14 people sitting in the jury box. And their role is to listen to the evidence that the state has. And basically what happens is once you're picked as a juror, you will come in and the judge will give preliminary instructions. And those preliminary instructions will be basically telling you that the state has the burden of proving every element of the crimes beyond a reasonable doubt, and that it is the jury's job to determine the credibility of witnesses. And what that is a fancy, it's not that fancy, but it's a fancy way of saying you have to listen to the witnesses that are testifying and make up your mind whether you believe what they're saying or not. And then and after the preliminary instructions, the judge will turn to the state and say, would you like to do your opening statement? Now, I know most people have seen shows like Law & Order or CSI or NCIS or any other crime drama type show. And those shows take a crime from the moment it's committed to the defendant being found guilty or discovering who's done it in an hour. That's not what happens at a trial. And you'll find in a minute, Charlie Barrow's going to get up here and talk to you a little bit about the rules of evidence. And then after that, Special Agent Peacock's going to talk to you a little bit about what forensic evidence is. But what happens at the trial is you begin with an opening statement. And that's when the state stands up and says, the defendant is charged with X, Y, and Z. And this is what we believe the evidence will show. And then we go through that. And then the defendant's attorney, he or she gets to stand up and say, the state's not going to be able to meet this burden for whatever reason. And this is our theory of the case. And then and the judge will tell you in his preliminary instructions, his or her preliminary instructions, that what we say in opening statement is not evidence. The decision has to be made by the jurors, and the role of the jurors at a trial is to listen, as Judge Osborne talked about. It's very important for them to listen to the witnesses on the stand, listen to what they say, determine whether they're believable or not. And after the opening statements have been given, what will happen is we'll start calling witnesses and they'll begin testifying. And the jury's role is just to determine who's credible. What do I believe? And how the jury comes to that decision, and what the lawyers do, if I'm the state and I'm presenting a witness, is I ask what are called direct examination questions. Those questions are who, what, how, when, why. I can't lead the witness. When I get done asking the questions, getting all the information from the witnesses testifying at the trial, when I get done with that, then the defense attorney gets to get up and ask cross-examination questions. And that's what you see most of the crime stories on TV about, is that the trial, when the direct examination happens, and then the cross-examination. And you can ask leading questions at that point. And the cross-examination is to attempt to point out to the jury the inconsistencies in what the witness has said, or information that they don't include that they're going to prove at a later time. And at the end, when both sides have had their opportunity to ask a question, then you move on to the next witness. One of the things that judges say in this circuit, and in any circuit I've ever practiced in, is they allow jurors to take notes. And they want them to take notes about what this witness is saying and why they believe them, or whatever they want to do. But their job is to determine, when they get back in the jury room, well, I believe this witness for this reason. Or I have problems with that witness said because of X, Y, and Z. And so what the jury is doing the entire time is holding the state to meeting its burden of providing proof that the defendant has committed the crime beyond a reasonable doubt. And during the course of the state's presentation or the defense presentation of its case, they will present, and you heard Judge Ray talk about what they look at on appeal as the record. And how the record is made is lawyers present evidence. Now, evidence can be testimony from the witness stand, or it could be documents or videotaped statements somebody's given. All of that information has to be presented. And Mr. Barrow will tell you in a minute what the rules of evidence require in order to present that type of thing. So the juror's role is to listen to the evidence that comes from the witness stand, the exhibits that are presented by both sides, and then once all of that evidence has been admitted and all the witnesses have testified, and basically the state will have its chance to present its case, and then it would rest. The defense can present its case, and the defense would rest. Then the state has an opportunity to present rebuttal evidence to sort of rebut whatever the defense witnesses might have said, and then the case is closed. And at that point, then there will be time for closing arguments. And basically, in closing arguments, it is the opportunity for both sides to come to tell the jury what they believe the evidence shows. And I think one of the most important things that a lawyer can do in trying to understand the role of a jury in a trial is to talk in a language that the jury can understand. Sometimes when we're in law school, we're taught fancy words like voir dire or voir dire, which is the Latin phrase for, to seek the truth. But you need to talk in terms that people can understand, because the goal of the prosecutor or the defense attorney is to communicate to that jury. And so in closing arguments, you spend a great deal of time explaining what the elements of the crime are, and then what evidence supports the fact that, in my position, the state has proven its case beyond a reasonable doubt. And then the defense can argue how the state has failed to meet its burden, or how what the state's saying is not what really happened in this case at all. And after the closing arguments, the judge provides what are called the jury instructions. And you heard earlier tonight people talking about that a jury has to make a decision based on the law. And the law comes from the judge. The judge will tell the jury, this is the law as it applies in Georgia. And you can go back there and make your decision based on the law as Georgia has made its law. And I want to, in closing, time is fairly short, just want to talk briefly about one of the jury charges that a jury would hear and a judge give them. And it's called credibility of witnesses. And this is what the judge would say to a jury. You must determine the credibility or believability of a witness. It is for you yourself to determine which witnesses or witnesses you believe or do not believe. If there are some whom you do not believe, In deciding credibility, you may consider all of the facts and circumstances of the case, the manner in which the witnesses testify, their intelligence, their interest or lack of interest in the case, their means and opportunity for knowing the facts about which they're testifying to, the nature of the facts about which they testify, the probability or improbability of their testimony, and the occurrences about which they testify. You may also consider their personal credibility insofar as if they have been shown in your presence and by the evidence. A jury is the one that determines who's telling the truth and who's not. Now, the state may believe that witness A, B, and C is telling the truth. A jury may not agree with the state. And that's why a jury is one of the most powerful tools in our democracy to keep us free. Thank you.
Thanks, Cliff.
Should I have introduced you?
No, sorry. I'm going to try to move ahead here because we're running a little bit behind, and we've got a great presentation by this GBI agent in just a minute. I'm going to talk very briefly here about the rules of evidence. What are the rules of evidence? The rules of evidence are the rules that govern the facts that are presented to a jury, what's admitted, what's excluded. And there are lots of rules of evidence. I can't go into all of them tonight, but they are heavily litigated by lawyers, and there are plenty of exceptions, and so it's a vast area. I'm holding up right here what's called the Georgia Rules of Evidence. It's a book that's over 1,000 pages long. It contains the rules, it contains the exceptions, it contains all the arguments lawyers have ever made about the rules of evidence. If you ever see lawyers and looking tired and haggard, it's because they have to read books like this. The general purpose of the rules of evidence is to make sure that good, accurate information is presented to a jury and that the parties are protected, that they're given a fair shot at trial. That's most rules of evidence. That is the underlying policy for the rules. I'm going to just talk about two rules that are probably some of the most heavily litigated and that may be familiar to non-lawyers out there. The first is what's called hearsay. I'm sure everybody has heard that term before, but you may not know exactly what it means. An example is, say person A witnesses a car accident. Person A then goes to person B and says, this is what I saw, X, Y, and Z. If we were to try to put person B on the stand at trial and person B were to try to testify as to what person A said, that would be hearsay. And that's generally not admissible. And the reason why, I can give you sort of an illustration of why we don't typically allow that. If you think of the children's game, I'm sure everybody knows this game, where you sit in a circle and a child whispers a statement into his neighbor's ear, and the statement goes around the circle, and the last person stands up and announces what the statement is. Inevitably, it has changed as it's passed through each of these people. And that's sort of the general premise behind the hearsay rule is we can't trust information that has passed through another human being because of human error. Now, there are multiple exceptions to the hearsay rule, and they would make you go cross-eyed if I tried to explain them all to you today. But I'm just going to give you one basic one that I think everybody could probably remember and understand easily. It's called the dying declaration. So, say we've got somebody who's been shot, and he's on the ground, the police show up, and he is on his last breath, and he says, Cliff Howard shot me. And then he dies, and so he's no more. The officer who he told that to would be allowed to get on the stand and repeat that statement. Technically it is hearsay, but for certain reasons, the courts and the rules of evidence are going to allow that statement to come in. And the reason being is we typically believe that somebody who knows he's about to die is generally going to tell the truth. And we can trust that statement more than other statements that would be hearsay otherwise. So that's an exception to the rule that would allow what is otherwise a hearsay rule into evidence. The other basic rule of evidence I want to talk about is what's called character evidence. This is sort of a broad term, but generally character evidence describes any evidence that reflects on somebody's character. That is, what kind of person the witness or a party may be, whether he's a bad person or a good person, whether he cheats or lies or does good things for the community. As a general rule, that kind of evidence is not allowed in a trial. The jury doesn't get to hear what kind of person the witness is or a party is, because, put quite simply, it can be distracting. An example would be if we've got a car wreck case and we've got a person on the stand who witnessed the car wreck, and he's testifying about what he saw and who he thought was at fault. And the opposing counsel gets up and starts asking him about whether or not he cheated on his wife. That's not going to be allowed. It's distracting from what's really the issue there, and the courts just don't want witnesses to have to undergo that kind of thing. I think the rule is most important, though, in criminal trials, and especially when we're dealing with criminal defendants. That's somebody who's on trial for allegedly committing a crime. His or her rights are highly protected, and it's generally not allowed that a defendant's criminal history or any other history of bad acts, those generally are not allowed into trial, into evidence. And I can illustrate the reason why with an example about children. I think most parents who have children might understand this, and usually when we're dealing with our children, our sense of justice is heightened. But suppose you've got Junior and you get a call from the kindergarten teacher, and you're called into class, and you're told, well, Junior hit Sally today. And the teacher says, well, I didn't see it happen. Sally says he did it, but Junior's saying he didn't do it. I'm going to believe Sally because 3 weeks ago Junior hit Joe Blow. Most parents are not going to be happy with that response. If their son or daughter is saying they didn't do it, and they're going to base what happened in the present case with some history of their child, that's generally not going to be accepted by a parent as a good reason to punish the kid. And that's the same in a criminal trial. If somebody's on trial for a charge, we do not necessarily want the jury to hear about his history, because they may not pay close enough attention to the evidence at hand and just say, well, he did it before, so he probably did it again in this instance. Now, like the hearsay rule, there are multiple exceptions, all of which I can't get into tonight. I'll give you one that's kind of simple, and you can probably remember it. And here's the example I give. Say we've got a guy who commits burglary, Joe Moron. He likes to go in houses, and what he does is he'll take a TV and then he'll carve an M into the wall, and that's how he commits his burglaries. So he does multiple burglaries like that. He's caught and convicted of those. Well, sure enough, we have another crime. There's a burglary, a TV stolen, and there's an M on the wall. Police go out and arrest Mr. Joe Moron, and at trial, the state's going to want to introduce evidence of all these past burglaries. And the rules of evidence most likely are going to let those past burglaries come in because they're so distinctive. They're committed in such a distinct way that it's going to tend to show that in this present case, it probably was the same guy who likes to carve M into the wall after he commits a burglary. So that's one exception. We've got the general rule and at least one exception as to when character evidence is permitted. So as you can see, these rules have reasoning behind them. There's a basic policy behind them. It's in the interest of presenting accurate evidence and giving the parties a fair trial. And when you hear lawyers stand up and object to trial, what they're saying is, this is violating a rule of evidence. This should not be coming in. But that is a general primer on the rules of evidence. We next are going to have GBI agent Britt Peacock, who's going to talk a little bit about forensic evidence for you.
We cover 11 counties, Walton County being one of our counties. I'm actually assigned to the crime scene specialist unit. So whenever you see the big GBI crime scene truck rolling through in Walton County, it's either me or my partner driving it. All right, this should work. Thank you. I told that I was having 20 minutes. It's supposed to be over 8:30. If you have prior engagements, I won't get offended if you have to get up and walk out, so don't worry about that. I was told that they wanted a PowerPoint. I'm the only one with a PowerPoint to show up on forensic evidence, but I included a little bit about crime scene. I'm glad I did. I didn't realize students were going to be here, so it worked out perfect. And a little bit about bloodstain pattern analysis. Now, I didn't go into any great detail because in 20 minutes you're just scratching the surface. Let me see if I can get this contraption to work. All right, crime scenes. We'll start out with crime scenes. Crime scenes are the locations where the commission of a crime is linked to that location. There's two different types. There's the site where the actual crime occurred, and then there's secondary sites where the activities related to a crime takes place. So if I shoot Judge here in this courtroom, and I jump in my car and I take off and I hightail it home, and that's where the cops find me at home, how many crime scenes do I have? Well, I have this one. This is our primary crime scene. That's where the crime actually occurred. The vehicle that I got into to escape, to go back to my house, and then obviously my house. You can start looking through these different things. We're not going to treat this one any differently than we are the vehicle or the house. We're going to take our time on that vehicle and house, even though there's not a body there. And typically, and that's usually the crime scenes that I'm at, is the ones that involve homicides. If there's not a body on the ground, we typically don't get called out of the crime scene unit. But those are the ones we've got to pay particular attention to, all those scenes, not just the one where there's a body on the ground. And a perfect case is Brian Nichols, I believe, was that the guy in Atlanta, shot the judge and a few other people in the courtroom. Then I believe he kidnapped a woman. But anyway, there was a huge trail of crime scene. Same thing with school shootings. I mean, that's one of our main concerns too. It's not contained to one room or one area. It's all over the place. And like I said, all sites are going to be important to the crime scene specialist. Once a crime scene is identified, the main concern is preventing contamination and securing it. And we deal with this all the time, and it's a huge problem because typically with immediate ones, it's pretty easy. Immediate, like a shooting at a convenience store. Police are on scene immediately. They put crime scene tape around it, and it's relatively secure, at least from the general public, not the police all the time, and I'll get into that in a second. The other ones are delayed, and that's bodies in wood that are buried in woods or buried anywhere else. It can take weeks, months, years sometimes to find those bodies. And one interesting fact that I learned when I went to NFA, the body farm up in Tennessee, was that it can take a body 8 times more to decompose in the ground than it does above ground. So if a body gets buried, you've got 8 times longer for it to decompose rather than it's just being on the ground where scavengers and everything else can get to it. And that's another thing we worry about at those sites. Weather's going to have an effect, especially temperature, on the decomposition. Animals, scavengers are going to tote off different parts of the body. And securing the scene still remains critical to the integrity of the scene, because that's going to come in on your testimony during court. And I'm sorry if I'm trying to move along fast. I just want to try to get everything in and not have anybody leave on it. All right. One of our main concerns with crime scenes is ensuring the personnel that enter a crime scene have a legitimate need to be there. And one of the problems that we encounter as GBI agents is we're never the first ones on the scene, rarely. We're always the ones that get called. So a local agency gets a 911 call, they show up to a scene, they've got a body on the ground. They start putting tape up. The problem with a lot of agencies is chief shows up, major shows up, captain shows up, sergeant show up, everybody starts trampling the scene. And that's exactly what you have in this picture. If you can see, I don't know how well you guys can see back there, but it looks like you've got 2 crime scene specialists, one taking the picture, one taking notes, maybe this guy collecting evidence. But then you've got a suit here, he's in the scene, You've got a major back here, he's within the tape, and you've got somebody else here, he may be the mayor or whoever else, he's on the cell phone. He's in the scene. And that's one of the problems that when I get to a scene I have to deal with, and I've had to deal with it on more than one occasion, especially coroners. I love coroners to death, but there's a time for them to go into the scene, and before the GBI gets there, that is not the time. We're trying to solve a crime. The coroner actually has jurisdiction over the body, but we have to clear the scene before the coroner can get to the body. Okay, so sightseers are not welcome. That's one thing when we go out and we're teaching different agencies what to do. An initial response to a crime scene is keep people off your crime scene. Your chief's going to come up 9 times out of 10 and want to go onto the crime scene. That's something you make sure you log it down and make sure he knows that you're logging it down. That's what we have to tell them. Because that list of people who enter that crime scene, that's going in my documents. And therefore the lawyers get a hold of that, and then chiefs start getting subpoenas. So if chiefs start getting subpoenas, they don't like subpoenas. They like their office, and they like the comfort of that. So that's one way of keeping them out of there. But I do encourage the DAs or the ADAs to come out to the scene. We've had that on specific scenes, especially where we know it's going to go to court. We recently had a double homicide where a gentleman killed his wife and 14-year-old son, and the DA over there showed up. We walked them through the scene. Of course, we have to make sure all the evidence is out of the way, and we have to create a path for them to walk through and see the scene. And we're able to do that, and I would encourage you to get in touch with whoever your local agencies are. If they know that there's a homicide that's going to end up going to trial, make sure you get that call. And it's up to you guys, obviously, but get out there and see that scene. That way you can actually say you saw exactly what was going on at the time. And I always welcome help. Anybody can help me hold a ruler or anything else. So you guys come on out. Contamination of the scene by non-essential personnel may compromise evidence and can taint the entire scene, potentially ruining a criminal case. Obviously, you guys know some cases have been lost just by this. Locard's exchange principle. Edmund Locard was a Frenchman. A scientist. I don't remember what other than that what his job was. But he came up with the Locard's exchange principle. And basically, what it says is, whenever you enter a crime scene, you deposit something there, and whenever you leave a crime scene, you are taking something away. Every contact leaves a trace. I know you guys have seen CSI. We get the CSI effect now. Some things are good and some things are bad. With the CSI effect, the jury expects everything to go just like they see it on TV, and you guys have probably dealt with that. In return, what we've got, since the juries expect that, our agencies are trying to buy the best equipment and everything they can to help us do our job better. And that's why we have that nearly $200,000 truck with all that equipment on it, so we can do our jobs better just because of all this media attention. I believe colleges have opened up. They've got more forensic studies programs now. So that actually ends up helping us in that area. All right, evidence. Going to talk about evidence for a minute. Evidence can tell a story of how a crime was committed. Tangible evidence is one type of evidence found at a crime scene, and that's something you can put your hands on. Weapons, drugs, projectiles, cartridge casings, tool marks. Transient forms of evidence taken from a crime scene may need to be examined by a lab. And this is fingerprints, blood, semen, hairs, fibers, body fluids, skin cells. That's another new one today. Not new one today, but that's the newest and greatest thing, is touch DNA. All right? So they're able to get, if I take, and it works better if you touch something that has a rough surface, as some of your skin cells actually come off like a piece of rope. If you're tying somebody up and you get your skin cells that come up off that piece of rope, they can actually test that rope and get DNA off of those skin cells. It's so sensitive that if they find a good fingerprint, we can swab a sweaty fingerprint and send that off and get DNA off of that. So those lab rats, as we call them, they're good at their job and thankful for it. The lab rats then report on these items and can often answer the question, who? Okay? How do we answer that question? Well, if they're in CODIS, that certainly helps us out. They're already in the system. Other than that, if we have a suspect and we can get a search warrant or consent, then we'll go get some buccal swabs from them. That's where we swab the inside of their cheeks. We submit that to the lab. The lab will then take that, the buccal swabs that we got from the suspect, compare it to the DNA that they got off a rope, fingerprint, whatever. Blood's usually the main thing we get from scenes. Forensic science, often shortened to forensics, is the application of a broad spectrum of sciences to answer the questions of interest in the legal system. Most fields have applications in the legal systems, which include biology, toxicology, chemistry, entomology, pathology, etc. Now, we at the lab, the state crime lab, we actually have a chemistry section, biology section, toxicology, pathology, who are the medical examiners, along with the firearms, latent prints, impressions, and trace evidence sections. So, what is forensic evidence? Well, forensic evidence is evidence that's usable in court, specifically evidence obtained by scientific methods such as ballistics, which is our firearms examiners, blood and DNA tests, the biology section takes care of that, hair and fiber identification, and that's trace evidence. Forensic evidence can be extremely helpful in improving your case, but there are rules and standards. These must be met before submitting, and these guys are the experts with those. I typically don't have to worry about that. All right, so scientific evidence is based off of knowledge that's been developed by the scientific method. What's the scientific method? Well, the basis for the scientific evidence has been hypothesized and tested and generally accepted within the scientific community. The methods used to develop these types of evidence are generally beyond the scope of knowledge that judges and juries possess and therefore normally introduced to scientific evidence. So that's where the experts come in, and they are able to answer the questions of how they know this particular thing has happened or this particular thing is reliable. For example, fingerprints have been around for hundreds of years, and they are now recognized in court as being valid. Identification using fingerprint matching is proven reliable over the years and is generally admissible as forensic evidence in a trial. This is another thing that when I was requested to try to focus on the blood pattern analysis. Now, BPA is based on the idea that blood will follow a certain set of physics, meaning that any blood spatter found at the scene could potentially be used to reconstruct the sequence of events that occurred. Now, I thought for years it was splatter. I never knew there was such a word as spatter until I became a GBI agent, but apparently they're both words, splatter and spatter. So it's interesting, spatter means smaller portions. Splatter is if I take a can of paint and splatter it on the wall, okay? Just for FYI. And analysts must be able to determine may be able to determine the movement and direction of the blood source, the position of individuals or objects during and after the event, and possibly the weapons used. All right. So the angle of impact. So the way these cards are made is we put these in a card slot with these different degrees on them. 90 degrees all the way down to 10 degrees. So, and I think I may have it on the next slide. So you can see a 90-degree impact. If I dropped it right here on the floor, that's just going to cause a circle, right? Okay? But if I hit something and it deposits it over here on this flat surface coming in at an angle, it could be around 20-degree angle. Now, why is that useful for us? Well, we can calculate the impact angle. How do we calculate the impact angle? We take the width, we divide it by length, and then we put it in the scientific calculator for the arc sin, and that gives us the degrees. I'll show you just an example in just a second. Right here is an impact pattern. So, if my victim's sitting here, I'm the suspect, and I take a baseball bat and I hit him, where's the direction of force? It's back this way, right? Okay, so when I hit that victim, blood is going to spatter on the wall. That is an impact pattern. So why is this useful to me? Well, I can take these things, these ellipses here, and I can measure those. And then I can take and I can draw a line in the direction that they were coming. Pick out several good ones, and all those lines where they meet are an area of convergence. So that's the height off of the ground that I know that impact occurred. but I still don't know this. I don't know where out here it occurred. I just know that it occurred in here, but not out here. So we take the width divided by the length and then sin arc, and that gives us the degrees. Then we come out, we use a protractor, and I believe that's in our next slide here. Maybe not. Maybe I forgot to put the protractor in there. Anyway, we get the degrees there. You guys seen Dexter? Anybody seen Dexter? You know what I'm talking about with all the stringing? Well, that's craziness. But that's typically what we do, not much. We probably pull 10 or 20 strings out, and it comes out to this area right here. Now, we'll anchor it on the floor down here, so where all those strings converge here, that's where our area of origin is. And so that's how I can tell and show a jury with pictures where the actual impact occurred. So if I'm hitting someone with a baseball bat, it shows that their head, usually where they get hit with, was right here at that time of impact. The problem is, they're usually falling to the floor and they keep hitting them. So we've got impact spatter everywhere at that point. And it takes hours to do that, all those impact spatters. All right, so I just explained impact spatters. Another type, cast-off. Cast-off pattern is a blood-stained pattern resulting from blood drops released from an object due to its motion. Typically, crime scenes don't have ceilings this high. They're usually 8 feet. So this guy that I'm hitting right here with the baseball bat, whenever I'm pulling that bat up for another swing, what am I doing? Blood, cast off. You can actually tell how many times he hit the guy from the number of cast off patterns. You can see here, this is just a light on the ceiling, and there's several cast off. This is probably the best, two best, one right there and one right there. And you can actually tell the direction. The tail of the ellipse always points to the direction that the blood is headed. So if you see this pointed that way, that means the blood was heading, the direction was heading that way when it came off. All right, so if I'm pulling it back and doing that, then the blood's going to be headed that way. You're going to see tails that way, so you know that's a backwards when he's come back. And then when he comes back forward, you can also tell that. He's usually deposited most of the blood off in the backswing, but when he comes back forward, you can sometimes get some of those. Drip stain is exactly what it sounds like. It's a blood stain resulting from a falling drip formed due to gravity. So if I'm standing over my victim and I've got a knife and it's dripping blood off the end of it, that's what you're going to see, just drip stains. If I take off running after I stab my victim, you're still going to have drip stains, but it's a drip trail at that pattern. And you can actually tell the direction of travel by the way the blood hits and leaves that tail. The tail always points to the direction of travel. Transfer patterns. A blood stain resulting from contact between a blood-bearing surface and another surface, such as a shoe print. So I'm here, I've already beat my victim, he's on the ground, and I leave and I step in his blood and I'm going to track that blood. Now, hardly ever do we get this. This is just an example that we pulled up. That's rare. You don't get that. That's pristine. We typically get half of that or a quarter of that or not much of that at all, but we have certain chemicals that we can spray on the ground, and we can luminol. I know you guys have seen them spray it on CSI, and everything turns up blue or a greenish blue, and we can pick those up. We also will take a ruler, we'll put down beside it, take pictures of it. That way we compare it to a suspect's shoe whenever we find the suspect. All right, swipe pattern, a blood stain pattern resulting from the transfer of blood from a blood-bearing surface to another surface with characteristics that indicate relative motion between the two surfaces. So it's similar to a transfer pattern. So if I have blood on my hand and I touch this wall, that's my transfer pattern, right? However, the minute I do that, it turns it into a swipe pattern. And I've got some good pictures I wish I'd have put in here of actual swipe patterns. Somebody, a guy that committed suicide, and he was trying to get to the alarm panel, and he didn't quite make it, so that was sort of eerie. White pattern, an altered blood stain pattern resulting from an object moving through a pre-existing wet stain. Very similar to your swipe pattern. However, this blood has already been deposited. It wasn't when I put my hand up here and wiped it. This is when I hit the guy, all this blood went up here, and then I rubbed on it somehow, rubbed my shoulder or my arm, and I swiped through it. You can see the outline. Whenever blood dries, it starts drying from the outside moving in. So you will have these rings. And the longer it has sit there and dry, the thicker these rings will be. And we actually, up at NFA, done that same thing. You'd take drops, and every minute you would wipe through them to see the size of the ringlet afterwards. Drip pattern, a bloodstain pattern resulting from a liquid that dripped into another liquid, at least one of which was blood. It's typically with us, it's always blood. And usually when we see this is when the victim is elevated and the victim is bleeding out on, like he's on the edge of the bed and he's bleeding out on the floor and it's just dripped. And these are called satellite stains. This is how I know that it's not just a couple of drips, is because the more blood that starts hitting that, the more satellite stains that you get there. Projected pattern. A projected pattern is a bloodstain pattern resulting from the ejection of a volume of blood under pressure. Now you ask, what could that be? Well, arterial spurt is a perfect example of that. So I stab a guy in the neck with an ice pick, which we actually had happen, and he starts spurting out. He's walking along or running along the wall, and you will see the arterial spurt. And you will see this projected blood pattern as he's trying to get away from this guy that stabbed him in the neck. Expiration pattern. That's a bloodstain pattern resulting from blood forced by airflow out of the nose, mouth, or a wound. Why is this useful? Well, it tells us that the victim was still breathing while he was getting beaten or after the beating occurred. So if he's laying on the floor here, and I come up and he's got all this blood around him and it's got the little air bubbles. I don't know if you guys can see it, but there's little air bubbles in this expirated blood. That means he's coughing or he's breathing whenever that blood's coming out. So he's still alive at that point. And we find that a lot of times on their chest and on their clothing if they're laying down on the ground. All right. Flow pattern, a blood stain pattern resulting from the movement of a volume of blood on the surface due to gravity or movement of the target. Why is this important? And I try not to put too many graphic pictures in there. I know there were a couple kids back there. I think maybe they're asleep. Why would this be important? Well, it's because blood, just like anything else on this earth, gravity moves it. So there is no way that this blood could have flowed over the leg in this direction. Okay? So what does that tell us? That tells us that the body has been moved. Okay? That wasn't the position the body was in when that person was laying there bleeding. So either they've moved the body or they were still alive moving around after it occurred. All right, that was short and sweet. I told them I went over 20 minutes a little bit, but guys, I really appreciate being here. If I'm going to have my business cards up here for the students. If you guys, we come out and we teach. We usually don't do 20 minutes. We usually do an hour-long presentation, and I just got this together in a couple of days. But I'll have my business card. You can give them to your professors, to your teachers. We can bring the crime scene truck out. We teach anywhere from first grade all the way up to college. So you guys give us a call if you want to set that up. As a matter of fact, my last class was a bunch of first graders, including my daughter. And the highlight of the class was when my daughter come up and slapped me on the rear end, and everybody just burst out into laughter. So I'm glad none of you guys did that. Appreciate it. So thank you. Thank you.
I want to thank everybody for coming out tonight. I hope everybody learned something, and that concludes our program.